Committee on State Affairs will come to order. Will the clerk call the roll?
Betancourt, Birdwell, LaMantia, Menendez, Middleton, Parker, Perry, Schwartner, Zaffarini, Paxton, Hughes.
Present. Good morning. The chair lays out House Bill 3137 by Representative Isaac and recognizes its sponsor, Senator Springer, to explain the measure. Good morning, Senator.
Good morning, Chairman Hughes and committee members. Recently, the city of San Jose, California became the first city in the nation to pass an ordinance that would require all gun owners to pay a $25 registration fee. For those gun owners would also have to carry a separate liability policy for their firearms after registering them. So what the bill does is in section 229.001 of the local government code, which already prohibits municipalities from adopting regulations regarding and relating to a host of activities related to firearms, weapons, and ammunition. In section 236.002 of the local government code, it prohibits counties from adopting regulations relating to a host of activities relating to firearms, weapons, and ammunition. And House Bill 3137 would add these prohibitions requiring an owner of a firearm to obtain, it would prevent, obviously, the requirement of a firearms from having to get liability insurance coverage. This is one just to make sure that we're protecting our Second Amendment rights, that undue processes, in fact, we're not putting regulations on it, goes from there. And with that, I'm happy to answer any questions, Mr. Chairman.
Thank you, Senator, for the layout. No questions from the committee, and so we will open public testimony, and the chair calls Noe Perez. Perez is the only witness we have registered at this time. If anyone wishes to testify on, for, or against House Bill 3137, please make your way to the kiosk just outside the chamber and register there, and we look forward to hearing from you. Welcome. Good morning. Introduce yourself.
Yeah, good morning. Thank you, Mr. Chairman. My name is Noe Perez, and I represent myself. I support House Bill 3137 because the bill improves the preemption laws. The 1985 municipal preemption law was passed to make sure firearm laws were uniform throughout Texas to ensure due process of law, as was mentioned earlier, a crucial component in our system of jurisprudence. House Bill 3137 is consistent with the tradition of the application of Dillon's rule here in Texas. This bill will ensure the consistent use of nomenclature in the prescriptive language used in both the county and municipal firearm preemption laws. Even though firearm ownership's regulations are currently proscribed, the legislature should make it unmistakably clear that insurance requirements are prescribed locally as well. This bill, coupled with the Code Construction Act, which applies the rule of lenity to local penal laws, will help ensure that Second Amendment rights are respected locally. I respectfully request that in the future this committee study the possibility that the rule of lenity be applied to sections 30.06, 4601, 02, and 03 of the Penal Code, since those provisions are malum prohibitum anyway. With that in mind, before I conclude, Mr. Chairman, just driving up here last night to the Capitol, I think I counted about 12 approximately counties. God knows about a couple of, at least 2 or 3 dozen cities. Hunting earlier this year, I think same thing. Texas is so large, you just never know what jurisdiction you're in. And I think that's kind of problematic here. And the way it works is, it's the dog that wags the tail. Our Constitution and you all are the bosses. That's just the way it works. And with Dillon's rule, and the problem with that, if you have one large city, let's say San Antonio, as an example, that can actually have a spillover effect of affecting the whole state, because you just never know when you're in one city or another because of the various geographic boundaries. So with that in mind, I respectfully request that the committee favorably report this bill. Thank you so much, Mr. Chairman.
No, thank you for your testimony, and we appreciate it very much. You made excellent points. I do want to correct one thing.
Okay.
You referred to the Constitution, and you were right, but then you said we're the boss. Well, we're not the boss. The people are the boss, but we represent them. So we're on the same page, but thank you for that. I appreciate that.
It was out of respect, Mr. Chairman.
No, you're very kind. I know. I love the sound of it, but it was important I corrected it. Thank you. And thank you for your testimony.
Yes, sir.
Thanks for being here. Thank you very much.
Thank you.
Is there anyone else wishing to testify on, for, or against House Bill 3137? Seeing and hearing none, public testimony is closed. The bill's left pending at this time.
Thank you, Mr. Chair.
Hopefully not for long. Thank you, Senator. The chair lays out House Bill 3949 by Representative Rainey and recognizes Senator Springer on behalf of the sponsor, Senator Whitmire. Senator, go ahead.
Thank you, Mr. Chairman. House Bill 3949 is helping to clarify a nonprofit, which is a 501c3 designation, is allowed to use arbitration to resolve internal conflicts between members. However, current law is unclear whether all nonprofit organizations can utilize this option, or if it can be utilized to resolve conflicts between the organization and a member. House Bill 3949 will clarify that nonprofits can use arbitration to resolve different conflicts within the organization. And with that, I'm happy to answer any questions on behalf of Senator Whitmire.
Thank you, Senator. No questions from the committee at this time. We'll open public testimony. And is there anyone wishing to testify on, for, or against House Bill 3949? We don't have any witnesses registered, but anyone is, of course, free and welcome to testify. Seeing and hearing none, we'll close public testimony. Bill's left pending at this time. The chair lays out House Bill 4843 by Representative Holland and recognizes Senator Springer on behalf of the sponsor, Senator Huffman.
Thank you, Mr. Chairman. This bill was originally very similar to Senate Bill 23, which was passed out of this committee and the Senate earlier this session. House Bill 4843 seeks to increase the penalty for the offense of unlawful possession of a firearm. Mr. Chairman, I do have a committee substitute to send up.
The chair lays out the committee substitute and recognizes the senator on behalf of the sponsor to explain the substitute.
The committee substitute amends the bill to mirror the language of Senate Bill 23. This establishes a 10-year mandatory minimum sentence for the use of a firearm in the commission of the most severe felony offenses under Article 42A.054 of the Code of Criminal Procedures. These are also known as 3G offenses. The bill requires 10 calendar years to be served for eligible offenses and removes the possibility for a judge granting or deferring adjudication, community supervision, or parole, but still allows jury recommended community supervision. Mr. Chairman, I believe this bill would allow Texas to take a stand against the illegal use of firearms in the commission of certain violent offenses. And with that, I close.
Thank you, Senator. No questions from the committee on that one, so we'll open public testimony on House Bill 4843. No one is registered to testify, but does anyone wish to testify on, for, or against House Bill 4843? Seeing, hearing none, public testimony is closed. Bill's left pending at this time. The chair lays out House Bill 4062 by Representative Harris of Anderson. 4062 is about the interview conducted between a child and a custody evaluator in suits involving conservatorship, possession, access to a child. Often the courts will employ a custody evaluator. Often a child may answer a question differently than they would in front of a family judge due to pressure from the evaluator or other interested parties. And obviously, if the court's relying on this work, that's going to affect the outcome, and the court will not be able to issue the right ruling without the best information, the best evidence. And so House Bill 4602 amends House Bill 4062 amends the Family Code to require a child custody evaluator to create an audio-video recording of each interview an evaluator conducts with a child who's the subject of a suit seeking conservatorship, possession, or access, unless the interview is conducted in the presence of all parties to the suit. And that's what the bill does. Open public testimony, and the chair calls Christy Trussler. Come on down. Welcome. Just pick any seat there, and when you get situated, we'll have you introduce yourself, give us your testimony. Take your time.
Okay.
Go ahead.
Hi, my name is Christy Trussler. I am a board-certified family law specialist and a board-certified child welfare specialist, and I'm also master's level trained in collaborative divorce. And we are, my firm, we're opposing this bill only because it says audio-visual instead of audio or visual. And the problem is we have a very limited number of qualified PhD candidates that do child custody evaluations. We also have, in some counties, like here in Travis County, we have a domestic relations office where there may be people that aren't PhD level and wouldn't otherwise qualify to do child custody evaluations. But when you bring these children into the mix, first of all, they're talking to an adult that maybe they've met once or twice. They're afraid. They're talking about really sensitive topics. And sometimes if you're out in a more rural county, this might be an evaluator come into their home. or bringing them into like a CPS office or something like that. They're terrified already. I've represented children. I have mediated for several years for the department. And I have a very, very busy full service family law practice now. And the concern is if you don't put or in between there, first of all, we're going to lose a lot of qualified evaluators because there's been a lot of talk about it and they're saying we're not going to do it. It violates their standards. We're not going to get genuine testimony from these children. It is the fear. And I actually have an adult child who's a graduate of Regent School of Austin here in town that was coming to testify about what it would have made him feel like. And he went through this. He went through 2 or 3 years of litigation. He wrote his senior thesis on this topic. Like I said, he's an adult now. I believe he's 19 or 20. He does not even know what I look like. I don't interview children of my clients. I represented his mother. But I don't know if he'll get here in time to testify. I know he very much wanted to. But that is our big fear. We don't want to lose credible or valuable testimony of these children, and we don't want to lose qualified evaluators that we have. And I know there's a workaround where if there's a court order, sometimes those standards they're saying, those won't be a problem with having the testimony admitted, but these evaluators are scared. These litigants go onto social media, they write about them, they file complaints against their board. This really needs to be an or. And I'm not saying I think the system is at all perfect and it doesn't need reform, because it absolutely does. But I'm afraid that without an or in between audio and visual, we're going to do more harm than good. And I've been doing this for longer than I would like to admit. I graduated from Georgetown University Law School in 1996, did about 6 years in big law, and then I've been in family law really ever since. And kids are my passion. My mom was a CPS worker, and most of us that are drawn to this area of law are not here by mistake.
You bet. Let me then thank you for your testimony. I have a couple of questions for you. And again, we're glad you're here. We want to hear all sides, and we value your experience. It's so audio or video, so it sounds like you're okay with an audio recording. And so, and again, I'm not putting words in your mouth. You're experienced. You know what you're doing. Recordings, audio versus video. Now, I would think you and I would agree that in court settings, it's nice to be able to look at the witness and to look at the person questioning the witness. And if it's audio only, forgive me for an extreme example, but how do we know if there were cue cards or subtle or not so subtle gestures? Or again, I'm not suspecting anyone of doing anything wrong, but does an audio recording give us the full picture of the interaction between the one asking the questions and the one giving the answers?
If you have a trained evaluator, I think yes, because they know what cues to look for. They're supposed to write those down. If you're looking at a PhD level person that's doing this, now I realize when we're talking about the DRO, the Domestic Relations Office, CPS, we don't have that luxury, unfortunately. And maybe they're in a room where, if it's hidden, if the child doesn't know they're being recorded, that's one thing. But if you go into a child's house in their living room and say, hey, no one's going to see this, they're terrified. You're going to show it to their mom, their dad, uncle, aunt or uncle, whoever that might be their abuser. I think there's a possibility of it doing a lot more harm than good. I think if you can do it surreptitiously, absolutely. I mean, maybe there's a way to work it where in CPS cases or DRO cases where you do not have these PhD level people, then maybe it has to be at a facility and it is audio and video. But if you put cameras in these kids' faces, I just don't think they may not talk anyway, right? Okay. So.
Thank you for your testimony. Thanks for taking the time to come down. Thanks for your testimony. Is there anyone else wishing to testify on, for, or against House Bill 4062? Seeing and hearing none, public testimony is closed. Bill's left pending at this time. In a moment, we're going to break for a very important event in the Senate chamber. We do have time for a bill before we do that. And the chair lays out House Bill 3742. House Bill 3742. And that's Representative Goldman's bill, sponsored by Senator Paxton. I'll present it on her behalf. House Bill 3742 will give the Texas Department of Licensing and Regulation the authority to authorize elimination tournaments, events in which a contestant is eliminated after losing and the winner is promoted to the second round. Provide ringside positions immunity from civil liability arising from acts within the scope of the position's responsibilities if the position acted in good faith. So what the bill does, and we will open public testimony on House Bill 3742. I'll ask, is there anyone wishing to testify on, for, or against House Bill 3742? Seeing and hearing none, public testimony is closed. The bill is left pending at this time. The chair lays out House Bill 461 by Representative Smith and sponsored by Senator Paxton. It has to do with adoption evaluation. The current adoption process is expensive and time-consuming for prospective adoptive parents. Its requirements for individuals who do adoption evaluations have increased. We've seen a decrease in the number of people offering these services. Across the state, we're dealing with a shortage of adoption evaluators. This increases the time it takes for an adoption evaluation to be completed and, of course, drives up costs. This bill seeks to alleviate the cost and lengthy time frame of this process by allowing the court, in a suit for adoption that is uncontested, to waive the adoption evaluation requirement for prospective adoptive step-parents. Many times, the children involved in these cases have lived in the step-parents' home for many years already. The bill still would require a review of investigative records of the Department of Family Protective Services and any criminal history maintained by the Department of Public Safety. That's what the bill does, and I will yield for questions. Very good. No committee questions. We'll open public testimony on House Bill 461. Is there anyone wishing to testify on, for, or against House Bill 461? Seeing and hearing none, public testimony is closed. The bill is left pending at this time. The chair lays out House Bill 1737 by Representative Leach and recognizes its sponsor, Senator Zaffarini, to explain the measure.
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 1737 by Representative Jeff Leach is co-sponsored by Senator Perry. It relates to automatic orders of non-disclosure of criminal history record information for certain misdemeanor defendants following successful completion of a period deferred adjudication community supervision. The House passed it unanimously. Generally, members, House Bill 1737 would direct DPS to inform courts monthly about persons currently eligible for automatic non-disclosure, require courts to issue non-disclosure orders to eligible persons upon receiving DPS notifications, and eliminate the need for any fee for automatic non-disclosure orders. That's all it does.
Thank you, Senator. Any questions for the sponsor? Very well. We'll open public testimony on House Bill 1737. Is there anyone wishing to testify on, for, or against House Bill 1737? Very good. Seeing and hearing none, public testimony is closed. Bill's left pending at this time.
Thank you. Let me see if it was 71. Let me see if it was 71. Do we have resource witnesses or what? For 371, I thought I just had a resource witness. Do I have witnesses for 371? 371? Say what? Ed Johnson.
The chair lays out House Bill 4697 by Representative De Ayala and sponsored by Senator Betancourt. And on his behalf, will present the bill. There's a statewide bipartisan concern over improving the integrity and transparency of the post-election audit process. This bill will standardize the audit process regardless of how or when Texans cast their ballots and apply existing audit procedures for Election Day and early voting. Good bill about transparency and consistency in our elections, and I'll yield for your questions. There's a committee substitute. It's being prepared, so we won't be voting on the bill till that's here, but that's what the bill does. We'll open public testimony on House Bill 4697. Anyone wish to testify on, for, or against House Bill 4697? Seeing and hearing none, public testimony is closed. The bill's left pending at this time. The chair lays out House Bill 2626 by Representative Tepper, sponsored by Senator Perry. Bill has to do with campaign finance reporting. Currently, candidates are required to report their campaign finance reports to either a local office or the Texas Ethics Commission, depending on whether the candidate seeks a local or statewide office or an office that covers multiple counties. HB 2626 would increase transparency by requiring all political subdivisions that receive campaign finance reports to make the reports publicly accessible on their government websites and maintain the report online for at least 5 years. Good bill about transparency, and I'll yield for questions. Very good. We'll open public testimony on House Bill 2626. Is anyone wishing to testify on, for, or against House Bill 2626? Seeing and hearing none, public testimony is closed. The bill's left pending at this time. In a moment, the committee is going to stand at ease for an important ceremony taking place on the Senate floor. And so we will be returning. The event we're breaking for will be on the Senate floor, so it'll be pretty obvious. So the Senate Committee on State Affairs will stand at ease at this time. That's right. Please participate and enjoy the presentation with us. Committee on State Affairs will come to order. The chair now lays out House Bill 1848 by Representative De Ayala, sponsored by Senator Hall, who is recognized to explain the measure.
Thank you, Mr. Chairman and members. House Bill 1848 will direct the Secretary of State's office to conduct a study of the cost and feasibility of conforming each central counting station with a sensitive compartmental information facilities standard and whether it would be beneficial to election security. These are standards promulgated by the federal government and can be used in reference to a data center or a secure room that guards against electronic surveillance and the leak of sensitive information. It is a set of standards that exist in the military context. The purpose of the study is to learn if some or all of the sensitive compartment information facilities, otherwise known as a SCIF, would be beneficial to further securing our elections. With that, I'd be happy to answer any questions.
Thank you, Senator. Any questions from the committee? Very well, we'll open public testimony, and the chair calls Ed Johnson. And Senator Hall, we have a resource witness from the Secretary of State. I don't have any questions for them. Do you? Do you want the resource witness?
No, I'm good.
Okay, very well. Mr. Johnson, welcome. Have a seat there, and when you get situated, introduce yourself and give us your testimony.
Yes, Ed Johnson, and for the bill. I think this would be a great idea. You know, we always have a lot of concerns if our systems are being hacked, especially when the counting process is going on. This would make sure that the computers and voting systems are secure. I don't think that this would be a great cost to do. We actually, when I was in the elections in Harris County, had similar things like this that we put into place. All this equipment to make a SCIF room is readily available. So I would appreciate the study to see if we could implement this in Texas.
Thanks for your testimony. Members, any questions for Mr. Johnson? Very good, thanks. Anyone else wishing to testify on, for, or against House Bill 1848? Seeing and hearing none, public testimony is closed. Bills left pending for now. The chair lays out House Bill 2961 by Representative Cook, sponsored by Senator King, and I'll explain the measure on his behalf. It's about jury instructions in certain conspiracy criminal cases. In Texas, a person may be convicted of capital murder under the law of parties for the criminal conduct of another. Right now, under 7.02 of the Penal Code, a person can be found guilty under the law of parties, quote, if in the attempt to carry out a conspiracy to commit one felony, another felony is committed by one of the conspirators. All conspirators are guilty of the felony actually committed, though having no intent to commit it, if the offense that was committed in the furtherance of the unlawful purpose and was one that should have been anticipated as a result of the carrying out of the conspiracy, end quote. However, the law of parties doesn't, in our law today, include a definition of conspiracy for juries to use when they're deliberating these cases. House Bill 2961 adds a definition for conspiracy to 7.02 of the Penal Code. The definition borrows from the criminal conspiracy offense in the Penal Code to define conspiracy as, quote, an agreement between two or more persons to commit a felony. That's the definition. This will give jurors clarity as they deliberate in important cases and will help with justice. So with that, I'll yield for questions. Very well. We'll open public testimony. The chair calls Lindy Borchardt. Thank you for being here. Lindy's the only witness we have registered at this time on House Bill 2961. If anyone wishes to testify on, for, or against, please register at the kiosk outside. Welcome. Introduce yourself. Give us your testimony.
Thank you. Chair Hughes and members of this committee, I'm Lindy Borchardt. I'm an assistant criminal district attorney in Tarrant County, and on behalf of Phil Sorrells, the criminal district attorney, I fully support House Bill 2961. This bill includes a straightforward definition of conspiracy in the law of parties. Conspiracy is defined as an agreement between two or more persons to commit a felony. It is important to include this definition in the law of parties because then it will be incorporated into the jury charge. Right now, the law of parties is used in some of our most serious of criminal offenses, such as capital murders. As you can imagine, capital murder is very difficult for jurors, as it should be. Including the definition of conspiracy in the jury charge in the law of parties for a capital murder case will guide the jurors in their deliberations and further criminal justice. I'd like to thank Senator King for sponsoring this bill, and if you have any questions, I'd be glad to answer them.
Thank you for your testimony. I bet everybody understands the law of parties. You explained it so well. Just in case, this is related to old doctrines, but the law of parties we've had for a while. And so if you and I agree that we're going to commit a felony, and that's all we're going to do, but then I commit another felony that was foreseeable, you're on the hook for that as well. Is that a rough description of the law of parties? You can correct me. It's okay.
That's an excellent description of the law of parties. It has the necessary safeguards because it has to have been anticipated, and that's an important safeguard that the law of parties has, and that's exactly how it works, again, especially in some of our most serious of cases of capital murders. And this definition will clarify and help jurors through their deliberations.
Thank you for your testimony. Members, any questions for the prosecutor? Thanks for being here.
Thank you. I appreciate it.
Is there anyone wishing to testify on, for, or against, anyone else on, for, or against House Bill 2961? Seeing and hearing none, public testimony is closed. Bill is left pending at this time. The chair lays out House Bill 1087 by Representative Hull, sponsored by Senator Middleton. Today, when the Department of Family Protective Services decides to remove a child from a home, they're required to make what are called reasonable efforts to prevent the removal. The standard is important, so important the federal government mandated this requirement in the Adoption Assistance and Child Welfare Act of 1980, where it has continued ever since. States cannot receive funding in this area if they do not make this reasonable effort before removing a child. A family law judge described it this way: the reasonable efforts findings are the most powerful tools given to the courts by the federal legislation. These findings enable the court to determine whether the agency has done its job to prevent removal. The judge went on, another problem is that most judges do not carefully address the reasonable efforts issue. They do not question the social worker who made the removal, end quote. This bill amends the Family Code to require that the affidavits and Department of Family and Protective Services petitions and court findings contain a specific description of each reasonable effort that was made rather than just a boilerplate recitation that it was done. By requiring affidavits to contain the actual reasonable efforts that were allegedly made before being allowed to remove the child, the department will meet the federal and state standard that's in place to balance the safety of the child with the efforts that should be made to prevent the traumatic process of removal. That's what the bill does, and I'll yield for questions. We'll open public testimony. No one has registered to testify on, for, or against House Bill 1087. So I'll ask, is there anyone wishing to testify on, for, or against House Bill 1087? Seeing and hearing none, Public testimony is closed. Bills left pending at this time. The chair lays out House Bill 371 by Representative Busey and recognizes its sponsor, Senator Zaffarini, to explain the measure.
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 371 by Representative John Busey relates to the date of runoff elections. Members, this bill would standardize the runoff elections date for May and November elections, requiring the runoff election to be held on a Saturday designated by the Secretary of State that is between 30 to 45 days after the date of the main election and not on a state or national holiday, and prohibit an early voting period for runoff elections that includes a national or state holiday.
Thank you, Senator. Any questions for the sponsor? We'll open public testimony, and the chair calls Ed Johnson. We also have a resource witness from the Secretary of State. I don't have any questions for the resource witness. Does any member of the committee? Very well. Mr. Johnson, get situated there, then introduce yourself and give us your testimony on 371.
Yes, Ed Johnson. I'm for House Bill 371. Sorry, it slipped up there. This is really a good thing because there is and there's still a flexible on when you can hold this election, runoff election, and that's due to you always have a move in when Thanksgiving holiday is. So you don't want to start early voting when Thanksgiving is, so you got to have that flexibility to move it. And we're allowing the Secretary of State to set that date. So early voting doesn't start on Thanksgiving, and it ends before Christmas. But it sets it on a uniform date. That way all runoffs are on the same day. Right now, currently, you'll have school district, they'll have it on one weekend, and the city has it on the next, and it gets real confusing to the voters. So this will help clarify and make it just a date.
Thank you.
Thanks for your testimony. Any questions for the witness? Thanks for being here, Ed. Is there anyone else wishing to testify on, for, or against House Bill 371? Seeing and hearing none, public testimony is closed. The bill is left pending at this time.
Thank you, Mr. Chairman and members.
Always ready.
The chair lays out House Bill 3712, 3712, and by Representative Hernandez, and recognizes its sponsor, Senator Menendez, to explain.
Thank you very much, Mr. Chairman. Members, for decades, distributors' licenses, beer distributors, were able to provide malt, beverage, or beer samples to retailers. This allowed the retailers to sample new malt beverage products before choosing to carry these products in their stores. However, this practice was inadvertently prohibited during the 2019 TABC, Texas Alcoholic Beverage Commission Sunset Bill. What this bill, House Bill 3712, would simply do is reinstate the practice that was happening prior to that bill of allowing distributors, licensees, to provide malt beverage samples to retailers no more than 72 ounces. This bill passed in the House overwhelmingly with 133 votes in favor and 12 against. I believe there is the Counsel for the Wholesale Beer Distributors, Mr. Keith Strama, has been invited testimony. If you have any questions of the process, Mr. President and members, thank you for allowing this bill to be presented.
Thank you, Senator. Any questions for the sponsor? We'll open testimony. The chair calls Keith Strama. And to be clear, we're opening public testimony. As well, Mr. Strom is the only witness we have registered. If anyone else wishes to testify on, for, or against House Bill 3712, please go to the kiosk outside the chamber and register there. Mr. Strom, welcome. Introduce yourself. Give us your testimony.
Thank you, Mr. Chairman. Keith Strama, counsel for the Wholesale Beer Distributors of Texas, for the bill. Senator Menendez, of course, did a great job, as always, laying out the bill. And Chairman Hughes, it's been incredible to watch you work this morning. You're like a baseball player, can play every position. This bill is, as Senator Menendez says, it's very simple. Texas law for beer, more than any other product, really restricts anti-competitive behavior where you give gifts to retailers, and that's created the most competitive aisle of any supermarket because everybody's got the same playing field. There always has been one exception for malt beverages. It allows you to give a six-pack of a product that you have never sold to them before, so they can try it out, which is a reasonable accommodation, and it got lost in the combination, and this bill fixes it, and we're very grateful to you.
Thanks for your testimony, for your encouragement. Members, any questions for Mr. Strama? Very good. Thanks for being here.
Thank you.
Is there anyone else wishing to testify on, for, or against House Bill 3712? Seeing and hearing none, public testimony is closed. The bill is left pending at this time. The chair now lays out House Bill 4507 by Representative Moody and recognizes its sponsor, Senator Alvarado, to explain the measure.
Good morning, Mr. Chairman and members. House Bill 4507 will further protect Texans from price gouging by explicitly allowing district and county attorneys to bring an action to enforce the anti-price gouging provisions of the DTPA concurrently with the Attorney General during a declared emergency. Those of us that have been through hurricanes or other natural disasters, we've seen many times how this can happen, whether it's water or building supplies, lumber, and things like that. House Bill 4507 expands the enforcement of the anti-price gouging provision of the DTPA to include district and county attorneys during declared gubernatorial or presidential emergencies. We do have some resource witnesses here from the Texas District and County Attorneys Association, if you need. Thank you.
Thank you, Senator. Members, any questions for the sponsor? Very well, we'll open public testimony. Is there anyone wishing to testify on, for, or against House Bill 4507? No one has registered, but of course anyone is welcome to testify. Seeing and hearing none, public testimony is closed, and House Bill 4507 left pending at this time. The chair lays out House Bill 4053 by Representative Johnson. Folks in elected or appointed office are familiar with personal financial statements annually required by candidates and office holders, and important resource to make sure there's transparency and conflicts of interest are noted and the public can be aware of any concerns. The document, of course, has become cumbersome, overreaching, and transformed into more of an indication of wealth than an indication of potential conflicts of interest. Many redundancies. It's an unwieldy document that requires hiring an attorney many times just to properly complete for fear of making an error. House Bill 4053 addresses redundancies within the personal financial statement and also simplifies the document, importantly, while it preserves its original intent of meaningful disclosure of real or potential conflicts of interest. For instance, the bill removes the redundant requirements for filers to report ownership of business associations, as this is already required to report in the description of interest in business entities. And again, for anyone who's looked at those definitions, it is hard to tell which one or whether you're supposed to do both. House Bill 4053 further directs the Ethics Commission to combine categories where possible and limit redundant reporting. The bill also streamlines a number of categories, omitting the requirements to list amounts or numbers of shares, as well as the if sold section for certain sources of income, including retainers from income from interest, dividends, royalties, trust income, mutual funds, stocks, etc. The public absolutely has a right to know what an office holder's sources of income are, so the public can determine whether or not there's a potential conflict of interest for a candidate or office holder. The existence is what matters. The specific amounts are not relevant to that inquiry. And so with the exception of a handful of important sections that we added in the 85th legislature, this chapter has not been substantially updated in 20 years. The financial world has changed a lot during that time, and so this bill will modernize that process. And I'm happy to yield for your questions. We'll open public testimony, and the chair calls Stefan Zapparali. Stefan Zapparali. We also have a resource witness here from the Ethics Commission if anybody has a question for the resource witness. And Stefan Zapparali has registered to testify on the bill. And I don't see anybody in the gallery or down here making their way here. So is anyone wishing to testify on, for, or against House Bill 4053? Seeing and hearing none, public testimony is closed. Bill is left pending at this time. The chair lays out House Bill 1299 by Representative Noble, sponsored by Senator Paxton. 1299 provides clarity in the election code that a carrier envelope for a ballot by mail must have an ink on paper signature. Also creates a criminal offense if an electronic signature or photocopied signature is used. It's clearly stated that a photocopy or electronic signature is not allowed. Folks put on notice this is a criminal offense. We want to make every effort to make sure that our elections are reflecting the will of the voters. And so clarifying that an ink on paper signature is required will take one more step toward ensuring the voter is the person who's casting the ballot. Also assists the early voting ballot board or signature verification committee in completing their task of comparing the signatures of the voter requesting the ballot by mail with the signature on the carrier envelope returned by the voter. This does not apply to someone who under current law is allowed to assist a voter. So what the bill does, I'll yield for your questions. Very well, we'll open public testimony. The chair calls Ed Johnson. We do have a resource witness from the Secretary of State's office. I don't have any questions for the resource witness to y'all. Very well. Mr. Johnson, welcome back. Introduce yourself. Give us your testimony.
Ed Johnson, and I'm for HB 1299. Was that? Yes. And the layout really described it. The only thing the ballot board has to compare to or to use to validate that it is the voter that's voting this vote by mail ballot is the signature. If you allow people to copy electronic signatures and place them on ballots, you don't know who's doing that. So you almost have to have a hard signature on the application and the ballot so ballot board can validate them.
Mr. Johnson, thanks for your testimony. Members, any questions for the witness? Thanks for being here. Anyone else wishing to testify on, for, or against House Bill 1299? Seeing and hearing none, public testimony is closed. Bills left pending at this time. The chair now lays out House Bill 3159. House Bill 3159 comes to us from Representative Leach in the House. Today, Texas does not offer an accessible alternative for absentee ballots. So some voters who are eligible to vote absentee due to a disability, they have to disclose their voting selections to a person who is assisting them. House Bill 3159 creates an accessible absentee ballot system. This has come up in many situations over the years where for in-person voting, we've worked hard to make sure that folks with disabilities are able to cast a private ballot. And I say we've made sure many times we've had to be reminded and pointed out to us by our friends in the disability community. And so this is an important bill that will provide a method for folks who wish to use it to have a private ballot. When applying for an absentee ballot, the voter would indicate in a method established by the Secretary of State's office that they'd like to receive an accessible absentee ballot. A ballot would then be sent to the voter electronically. Then the voter would use assistance technology they already have, such as a screen reader, to mark their ballot. Once their ballot is marked privately, they would print and return the ballot in the same way as any other absentee ballot is returned under current law. We already do this for our military and overseas voters. They request their absentee ballots. It's delivered electronically. They print, fill out, and return the ballot in accordance with the same absentee ballot rules that apply to everybody else. This bill also grants the Secretary of State's office rulemaking authority to implement the system. We note that several other states have already done this: Oklahoma, Ohio, Nevada, Florida, to name a few. We are not expanding eligibility for absentee voting. These Texans already have eligibility. We're simply taking an existing process that's been working for several years and giving those who need adaptive technology access to that process. I think we understand here, I know we understand that pillar of democracy of the secret ballot, and this will extend that to folks who deserve it. They're Texans, they're Americans. That's what the bill does. I'll yield for your questions. Very good. We'll open public testimony on. Thank you, Senator. On House Bill 3159, we have a resource from the Secretary of State's office. Anybody have questions for the resource witnesses? I don't. We're certainly glad they're here. I don't need them on this bill. The chair calls Chase Bearden and Ed Johnson. It's our custom to go from left to right or right to left from your perspective. So, Mr. Johnson, you're in that position. So introduce yourself and give us your testimony.
Ed Johnson, and I am against 3159. Not that I don't want to help handicapped voters. I would like to do everything we can to help handicapped voters vote. But there are some problems with this in the election world with the HIPAA requirements, and the fact is you cannot challenge or qualify any handicapped voter that they are handicapped. So if someone applies for one of these electronic ballots, you will just have to give it to them with no questions asked. So that would, I would think, create a real problem, because you're going to be emailing ballots to everybody that says I'm handicapped with no validation. We have this problem right now with ballot by mail. It gets abused by people that aren't really handicapped, and it's a big problem. The other one that the intent of this was to have it where a handicapped person could vote at home and be secure with their vote and not have to show anybody how they're voting. The reverse is going to happen with this because when you have an email ballot, it's not on, and they print it out on their own paper, it's not an official ballot. So when it is mailed back to the office, that ballot will get opened by the ballot board and by the election office. It'll be taken out of the envelope and placed with the envelope, and then the ballot board will actually have to copy that ballot onto an official ballot so it can go through the scanner. So the whole ballot board will know how this person voted, plus everybody in the election office will have a chance to look at it. So it actually undoes the secrecy of the ballot when you mail these email ballots out.
Mr. Johnson, thanks for your testimony. You know the election process well, and the committee relies on you. I want to ask you about that second point you made about when the email ballot is printed and mailed back. How's it handled today for military overseas ballots?
So today, when a military overseas ballot comes back, it's normally in just a regular envelope. So you have to open it up to see what's in that envelope, and then you have the ballot exposed. So then they see it's a military overseas ballot that is not on paper that's scalable size to fit the scanner or with the barcodes required. So you have to then have a team of the ballot board and the election office, a team of people will get together and copy that ballot from that paper that was mailed in to an official ballot that they can run through the scanner that will read it. Then after it is scanned, all that is attached together along with the envelope and kept with the record, so you have a record of what was done with that ballot. So there are multiple people that actually see these email ballots when they come back because of the duplication process that has to occur in order to count the ballot.
No, thanks. That's helpful. I was curious what we're currently doing for military ballots and how this would compare. Thank you. Members, any questions for Mr. Johnson?
Just to follow up, Mr. Chairman. So Ed, if we use the same technique on these ballots, is that the appropriate solution? Maybe
that is what is being proposed in this bill, is that it's going to be just like an overseas military ballot. You're going to email it to them. They are going to have some device at their house that they're going to be able to vote it and then print it out and then mail it back to the office, is how this bill is currently written. So.
Okay, there may be a distinction without a difference here that I'm not understanding, but is the procedure that is in this bill the same as what we're using for military ballots right now?
Very, very similar, yes.
Is there some structural problem that needs to be fixed as between very, very similar? And I'll let Chase please answer that too.
Currently with the election equipment that we have, you have to have certified mail ballot paper with serial numbers on them. So it's almost impossible to get that on a regular printer because the pieces of paper, like in Harris County, are larger than they're 11 by 17s. They're not 8.5 by 11s. So it's a technical problem that you would have to solve. It would take massive reprogramming of the election machines to get it to where you could read a ballot printed off of any printer and mailed back.
Thank you.
Thanks, Senator. Thanks, Mr. Johnson. Any other questions for Mr. Johnson? Very good. Mr. Bearden, introduce yourself. Welcome. Go ahead.
Thank you. Chase Bearden with the Coalition of Texans with Disabilities. Appreciate your time. And I want to first start off by thanking Representative Leach and Busey and yourself, Senator, for carrying this and working on this with us. This has been a couple sessions that we've worked on this. We worked closely with the Secretary of State's office. I know the original bill, we actually listened to what some of the opposition had said during that, went back and worked on a committee sub that included a lot of the comments that they had made to make sure we covered some of those issues. And I believe I can address a lot of Mr. Johnson's issues that he brought up. I'll start off by saying, for the disability community, I think one of the big things is to remember many do need some accommodations. A lot of times what we used to hear is, well, you can use an assistant to do this for you or a trusted family member. And I think something that gets forgotten is that you don't always agree with your family. You don't always agree with your husband or your wife. And when they're helping fill out your ballot, I guarantee you a lot of times the peace in the house is going to come before what your true choice is. That's just one example. The other example being for many of our blind members is that, when someone is filling out your ballot at home, you have no idea what they have filled out. You don't know if they've gone through all the steps appropriately. And this is something where someone should have the time to really think through it. They're already used to using the devices that they use at home to be able to read this, and giving someone that right to print it out sign it, and we want to be very clear on that. We are not pushing in any way for this to be emailed back or to be electronically submitted. We want to keep it just like it would be as any of the military would send back. Now, yes, that is on a piece of paper. So to address the issue about would that not be a private ballot then, I think the concern is not about the ballot board or the Secretary of State's office. I think we have full trust in the way that it's going to work, and that we know that when that is being transferred over, it is being done by a Democrat and a Republican sitting down, making sure. I'm sure, Senator Betancourt, you know how this process works.
Very well, Chase.
We have no fear of that being the issue. What we want to see is that that person in their household or wherever they're having to cast their ballot are able to do it privately and independently like everyone else. And all we're asking for at the end of the day, this is not adding any new people. These are already people who could register to get a mail-in ballot. It doesn't change that. All it does is allow them to mark a box that says they want the accessible format. In the past, I know Senator Hughes and I talked about this, and the idea of, well, what about making Braille? You really want to throw everyone into a tailspin? Try getting a bunch of Braille ballots, and who would even know what they said and then get them read? That's not going to work. Plus, in the blind community nowadays, many are not even being taught. The technology and ability is there. This is a safe system, something we can use, and we're willing to work with any of the groups as the implementation goes through to make sure, because we do want this done right and safe, and we will continue working with the Secretary of State's office. If y'all have any questions, more than happy to answer them.
Thanks for your testimony. Senators, any questions for Mr. Bearden? Thank you for walking us through it.
Thank you.
And thank you both for your testimony.
Thanks, guys.
Thank you.
Is there anyone else wishing to testify on, for, or against House Bill 3159? Seeing and hearing none, public testimony is closed. Bills are pending at this time.
Could we do the time bills? That's 60 bills and local government to head after. Can we do them? Yeah, I'm just order. Can we do the time bills now? Okay, well. No, I spring the other chairmen that are desperate to be able to have to go run their committees after lunch. Okay. What's that? No, these are the time bills I need to do. Sorry.
Senators and those participating, we have 3 measures dealing with the same general topic, so we'll lay those bills out together, and then we'll take testimony on all of those measures. So the chair lays out Senate Bill 2329. Start with that one. Senator Betancourt, once you explain 2329, then I'll lay out the House bill, then you can lay out the JR, if that's okay with you. 2329, Senator Betancourt, you're recognized.
Mr. Chairman, thank you so much. I am highly indulged by the pleasure of doing 3 bills at the same time. Okay. This was the original bill that was filed that was going to be enabling legislation for the SJR, which we'll do after Senator Hughes lays out the House bill that came back from the House. We put in a substitute to conform with the process of having a plebiscite that folks can vote on whether they want daylight savings time or they want standard time. And I think it's a great idea to put that measure before the voters. And this bill was the original bill. It was filed well back earlier in the session. I think the House bill is modeled pretty closely off of it. Maybe almost exactly. That's right. But importantly, I think we need to give a chance for folks to vote on which time they want. And I know Senator Menendez, I've been working on this, how many? Years. Okay, so with that, we'll make the layout on the older bill, but the original and the pristine bill that was apparently used as a template for the House first. Thank you.
Yeah. Very similar to your bill, the seminal legislation, the fount.
Great minds think alike.
So we're going to leave that bill pending, and along with it, lay out House Bill 1422. The chair now lays out House Bill 1422, and that is the bill, again, on a similar topic. Comes to us from Representative Metcalf, and I'm the sponsor of that bill. And again, springing forward, falling back, we get it. It's been a source of frustration and angst for people, maybe especially parents. I've been reminded, parents of young children, for a long time. And so House Bill 1422 would authorize us to go on daylight savings time and stay there year-round, which of course gives us the maximum amount of daylight. The U.S. Senate passed the Sunset Protection Act in 2022, which would make daylight savings time permanent in the U.S. for those states who choose to observe daylight savings time year-round. The House did not pass that bill, but we're still hopeful the feds will take some action. Right now, states are authorized to observe standard time, not daylight savings time year-round, without approval from the feds. So this bill moves us toward daylight savings time, more light, more sunshine year-round. That's what the bill does, and I'll yield for questions.
We're going to do the plebiscite next.
All right, the chair now lays out Senate Joint Resolution 86 and recognizes Senator we're going to leave those two bills pending and lay out Senate Joint Resolution 86. Recognize its author, Senator Bettencourt.
And thank you so much, Senator Hughes. That was a good summary of where we're stuck, because we're really kind of stuck in between with Senator Rubio's bill being passed by the Senate, not by the House. So at this point in time, we could not authorize a daylight savings time year-round version because it's not allowed under federal law. However, we have the solution to what ails us here. I already have 4 joint authors of this morning. The SJR would allow Texans to decide whether they would stay on standard time or daylight savings time year-round. This would apply to portions of Texas using Central Time and Mountain Standard Time. If passed, the SJR would require a vote in the next general election. And basically, the layout would be really simple: observing daylight standard time year-round or observing daylight savings time year-round. I think this would be a perfect thing to put on the November ballot. And I know that when both bodies went to get together and do something like we did in the last day of this special session, we passed a homestead exemption bill in both houses in one day. So I'm hoping that lightning will strike twice, and we will give the public a chance to vote on the time that they want.
Thank you, Senator, for that layout. Members, any questions for the author? Brilliant. Well said. Well said.
Do I have a brilliant too? Then we're all 3 brilliant. Senator Parker, would you like? Never mind.
All right.
Well, we've got a hearing, so let's rock and roll.
So at this time, we're going to open public testimony on all 3 of these measures. So again, they're all related to daylight savings time, and folks who come up are free to testify for or against 1, 2, or 3. As you see fit. So we'll get through this because the subject matter is the same. It's much more efficient this way than asking the witnesses to come back 2 or 3 times. And so we'll now open public testimony on Senate Bill 2329, on House Bill 1422, and on Senate Joint Resolution 86. And to open, the chair calls the following witnesses: Ed Johnson, J.P., and Martha Hablitzel. So we're looking for Ed Johnson, J.P., Martha Hablitzel. Just come on down, take any seats you like, and we'll happy to hear from you.
Texas time. No, I've always had a.
All right, welcome to each of you. Again, hello. We'll again start on our left, your right, and start over here. So introduce yourself, give us your testimony.
Ed Johnson, and I'm for all three bills, just as long as we don't change the time anymore. I am a type 1 diabetic, and this is actually a very big change for me when this happens. Give you a little medical history. In the early morning hours, your body, your internal clock, kicks off a hormone that releases glucose from your liver that actually stimulates you to wake you up. And your internal clock does this. Your normal bodies actually then produce insulin to counteract the sugars that are released. Unfortunately, I don't have the insulin cells anymore, and I don't have that happen, so I have to take medicine to do this. When this time change happens and my internal clock gets out of balance, I usually end up having what they call low blood sugars. I pass out usually every time we have a time change. My wife has had to call 911 probably at least about 5 or 6 times now to come and revive me to get it, because it really messes up the balance of when I have to take this medicine to counteract the sugars in my body, and it can really mess you up. Diabetics, especially type 1 diabetics, dread the time change because you have to go through this adjustment period every time.
Thanks for your testimony. Welcome, introduce yourself, and go ahead with your testimony.
Thank you. Hello, Honorable Chair and committee members. Thank you for having me here. My name is JP. I'm the president of a nonprofit called Save Standard Time. We work across the country on bills like this. We work directly with the Society for Research on Biological Rhythms, the American Academy of Sleep Medicine, the American Medical Association, the National Safety Council, and many others who are opposed to the idea of permanent daylight saving time. So we would ask opposition to all three bills. We certainly would support permanent standard time. We like the idea of ending the clock change, but we warn that permanent daylight time is worse than the status quo. The reason being for that is that it would cause a permanent misalignment of our clocks from our circadian rhythms. It would force early waking. It would delay the sunrise until 8:30 in the eastern half of Texas and until 9 in the morning in the western half of Texas. I have a visual aid showing how that looks in Houston. It's normally sunlit in January with standard time, but it would be dark with the daylight time. And this is Quanah, Texas. It'd be pitch black at 8 in the morning if this permanent daylight time were put in place. It's been tried before, actually, in the 1970s and the 1940s. Going into it, there was a lot of enthusiasm, but as soon as that winter hit, it was strongly rejected, and Texas and many other states were begging Congress to undo this change. Mexico just recently, just last October, moved to permanent standard time. So if Texas were on permanent daylight, there'd be an hour difference at the border, and that would cause a lot of disruption to business and families. Many other states, Arkansas, Oklahoma, New Mexico, have previously rejected permanent daylight time. Arizona, Hawaii, and as I mentioned, the nation of Mexico are on permanent standard time. And that can end the clock change, but is also best for our health, our safety, our education, and our productivity. So again, the American Medical Association, the American Academy of Neurology, National Safety Council, and many others, even Chuck Norris has written 3 op-eds over the last year against permanent daylight time. So I would ask, please, your opposition to these bills.
Thanks for your testimony. Do you want to ask now or after we get through the panel, Senator? Go ahead, Senator Bendigo.
Since you studied it and you invoked Chuck Norris, so I have to ask a question. Could a Texas time solution? I believe some of our territories and some of the Pacific have a 30-minute differential. They have a 30-minute differential. I thought there's time zones in the world that
There are time zones in the world that have a 30-minute difference, and some even 45 or 15-minute differences. But in the United States, all of our time zones are offset by even hours from Greenwich, England.
Right now, so using Greenwich Mean Time as a standard, but I just was curious if you all had studied that, and also just from the standpoint of, do you have any problem with the plebiscite of letting people pick a time, even though without federal legislation it would just be data for the legislature to continue?
Well, I just pulled up on my phone what's posted on the website for these three bills, and they do not seem to offer the option of permanent standard time from what I've just read on the.
Well, no, if I could correct that, so you know. Let me just read what would it say. Hold a statewide referendum that allows the voters to indicate a preference for either observing the first preference as standard time year-round or second preference observing daylight savings time year-round. So it does offer standard time as an option.
And that's all three of these bills or just one of them?
SJR 86.
86, okay. Well, then my organization would take a neutral stance on that bill in that case.
Well, that's progress. But so check out 30 minutes for Texas time. See what you think.
But under the current federal law, only permanent standard time is permitted.
I'm just more of it. It's more of an academic exercise. I'm just curious to see what those partial hour shifts did. Thank you. Okay.
Thank you.
Thanks for your testimony. Welcome back. Introduce yourself to us. We know you. Give us your testimony.
My name is Martha Hoblitzel. It looks like Hoblitzel, but it's Hoblitzel. I inherited it when I got married. Thank you. I've talked to many of you. I've emailed all of you. It's nice to meet you in person. I met Senator Zaffirini when she was running for representative at Compton Hall umpteen years, maybe 20-some years, 30 years ago. Back before it was declared unusable. I represent the campaign to opt out of daylight savings time in Texas. I have 22,200 and some likes. I have over 21,000 followers in Texas. Unfortunately, I'm the only one of all these thousands that's here, but I represent them. I represent myself. Y'all are very smart at what you do. The educators, the lawyers, the economic specialists, you're very smart at what you do. And I've been fighting this daylight savings issue since March of 2014, back working with Representative Dan Flynn. It's been a learning process. The first thing I learned, it's not daylight savings time. There's no S. It's daylight saving time, which is almost impossible to say without the S. The second thing I learned is there's a Uniform Time Act. The Uniform Time Act allows states to do spring forward and fall back, have the biannual time changes, or like Arizona, where Mr. J, what's your name, P, is from, they do not do daylight savings time except on the Indian reservations. They have permanent standard time, and that must be a relief to not do the biannual time changes. The Uniform Time Act says that if a state wants to do daylight savings time, they will start, which is in March, and will end, which is in November, the same as other states. I'm old. I'm in poorer health than y'all. I may or may not be older than you are, but I'm not in good health. I need you to end time changes. I am against any bill that says we'll have permanent daylight savings time. My 22,000 followers are against daylight savings time. And SJR 86?
Yes, ma'am. Hang on. She's still testifying. Go ahead.
What is the number?
86.
If it allows for permanent standard time, I would favor that. If it allows for permanent daylight savings time, I'm against it.
Thank you for your testimony. We may have some questions for you, and thanks for being here. Members, any questions for any of the witnesses? Thank you all for being here. Thanks for your testimony.
Thanks again.
No questions?
No, ma'am.
Breaks my heart.
You did such a good job. We don't have any questions. You laid it out very well.
It's very nice to meet you in person.
It's good to meet you. Thank you.
Thank you. Thank you.
Anyone else wishing to testify on,
better.
for, or against House Bill 1422, Senate Joint Resolution 86, or Senate Bill 2329? Seeing and hearing none, public testimony is closed. All three measures will be left pending at this time.
It's JSJR. Thank you.
The chair now lays out, well, the chair was about to lay out House Bill 4621, and we will. And instead of explaining it on behalf of the sponsor, we'll let the sponsor explain it. House Bill 4621 by Representative Bajani. And the chair recognizes its sponsor, Senator Paxton. Or should we come back to that one, Senator? Oh, very well. On 4621, Representative Bajani's bill about canceling certain elections on ballot measures. And you're recognized, Senator Paxton.
Thank you, and I'm present.
We got you.
Thank you. Thank you, Mr. Chairman and members. I appreciate the opportunity to lay out House Bill 4621. Currently, state law allows a ballot measure to be canceled if it's declared moot. However, there is no meaningful option for a political subdivision to cancel an election on a measure in the case of a disaster. This bill seeks to address this issue by giving political subdivisions the option to reconsider an election on a ballot measure if a disaster declaration has been issued by the governor within 90 days of the election. I do have a committee sub.
The chair lays out the committee substitute and recognizes the sponsor to explain the substitute.
Thank you, Mr. Chairman. The committee sub for House Bill 4621 would allow a local authority that is conducting an election on a ballot measure to ask the Secretary of State for permission to cancel the election if the authority determines that a disaster has made it impossible to hold the election. The bill would only allow cancellations in disasters which are declared by the governor under Chapter 418 of the Government Code. In determining whether to agree to the cancellation, the Secretary of State would be required to take into account the effect the disaster has had on the area where the election is to be held and whether other elections are able to go forward. The version of the bill which passed the House would have allowed the authority conducting the election to cancel it without checking with anyone else, which raised concerns that voter rights were not properly protected by the bill. The House version also had a complicated schedule of dates governing when the election could be canceled. Both of these concerns are easily addressed by referring the matter to the Secretary of State for approval. As in the House version of the bill, if the election is the result of a petition by registered voters, a canceled election must be rescheduled for the next uniform election day. I do have a resource witness here from the Secretary of State's office. Thank you, Mr. Chairman and members, for your favorable consideration of the committee sub for HB 4621.
Thank you, Senator. Members, any questions for the sponsor? And we do have the resource from Secretary of State's office. I don't have any questions from them. Do you, Senator Paxton? Anybody? We certainly can call them if we need to. I don't have any questions for them. Very well. We'll open public testimony. The chair calls Ed Johnson. Mr. Johnson is the only witness we have registered on, for, or against House Bill 4621. If anyone else wishes to testify, please register at the kiosk just outside the chamber. Ms. Johnson, welcome back. And I know this is going to come up, but when you get started, let us know if you've seen the substitute and what you, if you have, and what you think about that. But go ahead, introduce yourself, give us your.
Ed Johnson. I was registered against House Bill 4621. I just heard your definition of the substitute. It does make the bill better. I would still have some things I would have to see the substitute to see. The ones that were really concerning me were the voter initiatives that are done by petition in a city. Under the current bill, if the city of Houston could have a voter petition that they could push off, and then they actually have in their charter that you can only have these petitions every 2 years. So now you're going to have an argument between their charter and the law on when the next available election is. So they could possibly push this out 2 years on a voter referendum, which I don't like. I kind of did some research into why this bill came forward. This was during the pandemic, and there was a school district that had a bond election in the May election, and it was canceled. Or the May elections due to the pandemic were canceled and moved to the November presidential election, which is one that I've seen this body try to move schools to the November elections. They did not want to have their bond election on the November presidential election. So this will give school districts the ability to, cancel their bond elections to put them back into a May.
Thanks for your testimony. And so, and I understand you were just heard about this substitute, haven't seen it yet. And
yeah, I have not seen it.
We appreciate you testifying, and you know how to stay abreast of these things. And so it sounds like the substitute was intended to address your concerns, and let us know what you think when you get a chance. And
okay, I will. Thank you so much. And
any other questions from Mr. Johnson, members? We're good. Thanks for being here. Is there anyone else wishing to testify on, for, or against House Bill 4621? Seeing and hearing none, public testimony is closed. Bill's left pending at this time. The chair lays out House Bill 3046 by Representative Cassell and recognizes its sponsor, Senator Paxton, to explain the measure.
Thank you, Mr. Chairman and members. House Bill 3746 does the following. During the 86th session, the legislature passed House Bill 1067 by Chairman Ashby, which allowed the authority responsible for preparing election ballots, excluding general, state, and county officer elections, to omit a candidate's name if they had passed away before the filing date. Currently, if a candidate dies after the filing deadline, their name remains on the ballot. House Bill 3046 aims to remove this timeline restriction and grants the authority the option to remove a deceased candidate's name at any point before printing ballots. While this issue may not affect larger areas with abundant resources and candidates, it poses significant challenges in rural communities where election resources are much more limited. Thank you, Mr. Chairman and members, for consideration of House Bill 3046.
Thank you, Senator. Members, any questions for the sponsor? We'll open public testimony on House Bill 3046, and the chair calls Ed Johnson. We also have Christina Adkins from the Secretary of State's office. I don't have any questions for her. Does any member need the resource witness? Very good. Thank you. Ms. Johnson, welcome back. I don't think there's a substitute on this one. Introduce yourself and give us your testimony.
Ed Johnson, and I'm here for 3046 House Bill. They made some changes from the House in this, limiting the size of the cities that can withdraw the names, and also extended the filing deadlines, which really helped this bill. You know, the intent that you don't want to have is leave voters without a choice of a candidate to vote on. You know, if one person dies and you only had two people in the race, that makes the default winner of the other one. So by extending the filing period, it does help that quite a bit. The other one that we need to, I guess, refine, or maybe if y'all can make sure that's clarified, is it says when the ballot is printed in this legislation. We need to, I would say you need to define that more particularly, because when you have a joint election, a November joint election with the city, you actually start that ballot creating process weeks before the ballot is printed. So if you let it to where a city could take someone off the ballot and you've already are 2 weeks into the process of creating the ballot, then these counties are not going to be able to get their overseas military votes out on time. So it really needs to be not when the ballot's printed, but when the process of creating the ballot is started.
Thanks for your testimony. Members, any questions for Mr. Johnson? Very good. Thanks for being here. Anyone else wishing to testify on, for, or against House Bill 3046? Seeing and hearing none, public testimony is closed. The bill is left pending at this time. The chair lays out House Bill 4780 by Representative Smith, and recognizes this sponsor, Senator Paxton, to explain the measure.
Thank you, Mr. Chairman. Thank you, members. House Bill 4780's main goal is to assist voters when voting by mail. Currently, the information found on the back of the official carrier envelopes for early voting is confusing and hard to read. This bill attempts to solve the issue by creating an optional signature sheet in lieu of completing the carrier envelope certificate located on the back of the envelope for ballots by mail. Doing so will allow the information to be in a larger sized font, which will help make the process easier to read and understand. The availability of a signature sheet is already available for use in the federal military and overseas for military and overseas voters. And just a personal note here, I know that in my mother's later years, I always helped her take care of these kinds of things, and I found it hard to read the tiny print on the back of the envelope, and that was before I needed readers all the time. So I think given the fact that so many of the voters who choose this method are in that situation, I think it's a great idea. Thank you, Mr. Chairman and members, for your consideration of House Bill 4780.
And thank you, Senator. Members, any questions? Any questions for the sponsor on House Bill 4780? We have Christina Adkins here as a resource witness. I don't have any questions for her. Does any senator need to hear from the resource witness? Thank you very much. We'll open public testimony on House Bill 4780, and the chair calls Ed Johnson. That's right. That's right, Senator.
Back one more time again.
Mr. Johnson, welcome back.
This is the last election bill.
All right, well, introduce yourself again.
Ed Johnson, and I'm against House Bill 4780. In at least all the large counties, the process for ballot by mail is they take the carrier envelope that the voter signs across the flap of the envelope, which actually is a security issue. signing across the flap of the envelope, you can ensure that the envelope hasn't been opened. And those are imaged. And then those images, along with the images of the applications, are presented to the ballot board where they can quickly verify this, to make sure it's the correct voter. And also saves records of all these. If the signature is placed inside of the envelope, the ballot envelope, they're going to have to be opened and then somehow marked and attached to that voter's file. It'll be a tremendous amount of work to get those signatures imaged and attached to the right, voters. Plus the security issue of you're actually going to have to open the ballot by mail envelopes to get these signatures out, which now leads to people having access to these ballots before the ballot board gets to them. I always wanted to try to keep those as secure as possible and keep those envelopes sealed without having to open them. I think the easier choice here is go with a larger envelope so you can get all the print on it. Many large counties have already had to do this because they have multiple languages they have to print on it, so they've gone to a larger envelope. It costs more in postage, but at least we can get all the requirements on there and keep the signature on the outside of the envelope.
Thanks, Mr. Johnson. Members, any questions for the witness? Thanks for being here. Anyone else wishing to testify on, for, or against House Bill 4780? Seeing and hearing none, public testimony is closed. The bill is left pending at this time. The chair lays out House Bill 969 by Representative Cook and recognizes its sponsor, Senator Middleton, to explain the measure.
Thank you, Mr. Chairman and members of the committee, for allowing me to lay out House Bill 969 by Representative Cook. At times in case of child custodial agreements between two separate parents, one parent does not abide by a court order that dictates certain visitation rights for the other. When that happens, a parent that seeks to see a child will be avoided or denied access by the other parent, prompting a call to the police. It is challenging to enforce interference with child custody order arrangements, and rather than arrest the offending parent under Section 25.03, law enforcement might instead encourage parents to go to court to resolve the dispute. House Bill 969 is a permissive bill. It would allow a municipality or county to adopt an ordinance or an order that imposes a civil penalty of not more than $500 for engaging in the conduct described by Section 2503 of the Penal Code, interference with custody child, and therefore, in addition to what is available under current law enforcement could be provided an alternative and a more effective measure, and hopefully parents will be more inclined to comply with court custody orders, and it also allows authorities to be better positioned to enforce those agreements with cities and counties having more tools available to them, and the entire process will be improved and Texas kids will be helped. When children grow up around both parents rather than just one, their lifelong expected outcomes improve, and with that I yield for questions.
Thanks, Senator Middleton. Any questions for the sponsor? Very good. We'll open testimony. The chair calls Scott Momper. Invited testimony on House Bill 969. And after Mr. Momper, we'll be looking for Steve Bresnan, Kimmy Lynn Reed. Mr. Momper, go ahead, introduce yourself, give us your testimony.
Good morning, sir. My name is Scott Momper, and I appreciate you guys having me here today. I've experienced this firsthand. I know what this is like. And basically what we're talking about is the definition of insanity, doing the same thing over and over again and expecting something different. Right now, with the current system of 2503, it's a state jail felony, and DAs are not going to enforce that. I've been personally told by DAs, we will not put a single parent in jail. This gives an option where we're no longer going to tie the law enforcement's hands, and it shows that there is hope, that we're putting accountability in a system where there is no accountability right now. It's a simple one-paragraph bill that can literally change entire outcomes of custody cases on the visitation side. So again, I do appreciate you guys' time.
Thank you for your testimony. Now we'll go back to our normal right to left. Mr. Bresnan, introduce yourself. Go ahead.
Thank you, Mr. Chairman. I'm Steve Bresnan here on behalf of the Texas Family Law Foundation in strong support of this bill. Right now, the options, as Scott stated, are to get a prosecutor to go after somebody for a state jail felony or to go back to court and seek a contempt order from the court. Both of those are resource intensive, expensive either to the state or to the private party, and they take the big courts time and resources to deal with. This provision, we have heard for the 15 years we've been representing the family lawyers, probably the single biggest complaint is that one parent's frustrating the rights of another parent. And they can do it with virtual impunity. This leads people to want to come back and change their orders to get different time, different schedules, and that's not really the problem. Enforcement is the ultimate problem. The beauty of the way this bill is drafted is it will allow cities and counties to develop ordinances and different systems for enforcing them, whether a citation will be issued by a police officer, whether someone can come down and file a complaint. And the $500 penalty may not sound like much, except when the person doesn't pay it, it can be enforced by a little bit of jail time. So I think this is an excellent allocation of resources and a great way to go after this. Strongly urge the committee to pass this bill out and send it to the governor.
Thank you, Mr. President. Oh, you don't ask now, sir. Go ahead.
Have we heard from all the...
Not yet. We have one more witness. We went out of order, but you go ahead if you'd like to.
No. Go right ahead.
Oh, thanks, Senator. Ms. Reed, welcome. Introduce yourself. Give us your testimony.
Hello. My name is Kimmy Lynn Reed. I represent myself, my son, Johnny Mason Murray, and Lone Star Family Advocacy. I'd like to start off with a few statistics with respect to high conflict divorce. High conflict divorce always contain at least one person to this personality disorder. In our community, 10 to 15% of the entirety of our community is personality disordered. As it pertains to the high conflict divorce, there is always one person withholding that child, and it is typically speaking the personality disordered individual as a means by which to exact pain on the opposing party. The one characteristic of these individuals is that they typically do not like anybody to infringe on their funds, on any of their money, and this is a motivational factor, specifically speaking to the personality disordered, because they do not give up their resources easily. In my case, Penal Code 2503 was never enforced, and I lost access to my son over 4 years ago. We all know that a child should have access to both children unless there is a situation that would permit otherwise. But unfortunately, because of the lack of enforcement on 2503, I lost access by virtue of parental alienation. Parental alienation is what occurs when there is no enforcement for the other parent to be able to obtain easy and regular access to the child per the court order. I believe with certainty, if this was already in place at the time 2503 was being violated in my case, we would have a different outcome for one child, my son, in the state of Texas.
Thank you for your testimony. Senators, any questions for our witnesses? Senator Menendez.
Thank you very much. Steve, you're aware of the fact that many of us in the building have worked on this issue for a long time.
Yes, sir.
And at times you and I have been on the opposite side of the issue, because I just wanted what the lady here just referred to, that children have access to both parents. If there is no extenuating circumstance that they shouldn't,
sure.
And if someone, the non-custodial parent has court orders, and I don't want the custody of the parents to be weaponized.
Yes, sir.
And to just because of your personal problems with your ex, you don't let your children see their other parent. And so I think I want to just say thank you to all of y'all for finally someone coming up with a solution that I hope fixes this. I've heard from many of my small police departments that they can time the calls they get from certain parents by the month that they're going to get called to that house because the certain parent does not want to let them see their children. So
yes, sir. This is a particularly creative approach to it that Senator Middleton and Representative Cook have taken, and I think it's well worth a try. It'll still be a weapon, but it won't be a nuclear weapon. So maybe it'll be more likely to be used and get some people's attention that are hard-headed.
Well, yeah. I mean, if the non-custodial parent is doing everything right and they have court orders, they shouldn't be robbing their kids. And I'll just finish with this. There was a Zoom call with a young adult child that said that their custodial parent hid birthday cards, hid gifts, hid and made them feel like the non-custodial parent didn't want anything to do with them. And that caused her a whole series of problems.
Sure.
And so I appreciate y'all working on this. I think we need to get
Senator
this.
Menendez, I'd like to say thank you because I was on that Zoom call with you. We brought that young lady to you, and she is the perfect example. And I would like to say thank you very much for all of your support in San Antonio, Texas. You've held the DA to account. You've interviewed him for us, and we are sincerely appreciative for all your work here.
I'm going to be signing on to this bill. It's something that's long overdue. Thank you.
Thank you, Senator. Members, any other questions? Thank you each for being here. Thank you very much.
Thank y'all for your service.
Is there anyone else wishing to testify on, for, or against House Bill 969? Seeing and hearing none, public testimony is closed, and the bill is left pending at this time. We have one more bill on our agenda for this morning, and the chair now lays out House Bill 4061. 4061. This bill filed by Representative Schatzline over in the House. Brooks Boundary is the name given to this bill. It comes from a tragic assault of a lady named Brooke Stevenson. When she was 14 years old, she was sexually assaulted by a neighbor. Our assaulter was convicted, served 10 years in prison, and is now a registered sex offender for life. Remarkably, hard for us to imagine, but after being released from prison, her offender moved right back into his old house next door to her family. Victims obviously face lifelong traumatic effects as a result of these crimes, and physically recovering, emotionally recovering. But this bill addresses a horrible situation like this. It prevents individuals who are on the sex offender registry from being within 2,500 feet of the resident of their victim. Now, when the bill came over from the House, it's obviously an important bill. We have a committee substitute who will clarify some of the elements from the House bill. And so at this time, the chair lays out the committee substitute. The committee substitute says the bill only applies if the offender goes into the affected area intentionally and knows that the victim lives in the affected area. It also says the bill will apply only to adult offenders, not juvenile offenders. It's an important change that the House agrees with in discussions. And also, again, it is about the victim of the offender we're talking about. That's what this important bill does, and I'll yield for your questions. Thank you, Senator. Very well. Open public testimony. I'm sorry, we'll start with invited testimony on House Bill 4061. The chair calls Robin Stevenson, Larry Stevenson. Take your time. Make your way over here when you get situated. We want to hear from you. Thank you both for being here to share your experience with the committee. And, do y'all care who goes first?
Go ahead. Okay. You want me to go?
I can go.
Okay, go ahead.
All right. Just to introduce yourself, give us your testimony. Welcome.
All right. My name's Robin Stevenson, and I live in Rowlett, Texas. And I want to thank each of you for allowing me to be here today. I'm sorry, I'm getting emotional. And thank you, Senator Hughes, for sponsoring this bill. I am in support of House Bill 4061. Sorry. As I request that the law of sex offenders be changed. While this law focuses on the protection of the children, this law does not provide protection for the victim. Once a sex offender is registered and released from prison, I am praying that there will be a hedge of protection around the victim to where that it would be unlawful for the registered sex offender to come within a 2,500-foot radius of the victim's place of residency, especially living next door to the victim. Sorry. I've been practicing trying not to cry. I am the mother of a child who fell victim of a sexual assault. My daughter was 14, as you had mentioned, when she was sexually assaulted by our 37-year-old neighbor who remained living at his parents' house and next door to our family. He received a 10-year prison sentence and was later released after serving his full sentencing and allowed to return living next door to our family and my daughter as a registered sex offender. And I'm sure right now he has no intentions of ever moving. I would like for each of you to imagine if this was your daughter. You have watched her over these years battle these triggers that this trauma has caused her. Everybody's focus is on the sex offender, but where's the victim's voice? Over the years, and I pray that she would get to a happy place in life. You realize the dreams you have her daughter for have been literally shattered by the sex offender who returned living next door to her. I'm sure you were thinking, as I did, how is he allowed to return living next door? I thought for sure the law would protect this from happening, but I was wrong. As I look at it, not only is my daughter a prisoner of her own mind, now she's a prisoner of her own home. She can't go outside of the front of the yard because he will go outside in the front of his yard. She can't go to the back because he will follow. He constantly taunts her, and it's a constant trigger for her. And she's in treatment today. It's still been in treatment, and she's actually in Tyler doing what they called microcurrent neurofeedback to help with her trauma. And we're hoping that will be successful for her. In order for us to protect our family, we have to move. I keep thinking to myself, why do we have to move? We've done nothing wrong. We're the victim here. But we're having to pay for his crime in so many ways. Why do we have to uproot our entire family, our entire lives, and the neighbors that we absolutely love and adore just so we can get away from him and protect my daughter? Today, in trying to find a house, we've looked. It's very hard finding one that is comparable to what we live in. And it would be very challenging for our children, too. I'm so sorry. I apologize. I pray that each of you will find in favor of this bill, House Bill 4061. And I, along with my daughter, would like to thank each of you for allowing me this opportunity to speak on this behalf of Brooks Boundary. I'm available for any questions that you may have, and thank you for your time. God bless.
Thank you, Ms. Stevenson. Thank you for being here. Mr. Stevenson, go ahead when you're ready.
Okay. Good morning, and again, thank you for...
Get a little closer to that microphone.
Yes,
we want to hear you.
All right. Sorry about that. Yeah, thank you for having us. There? Okay, thank you. My name's Larry Stevenson, and again, I'm here to voice my support for House Bill 4061, also known as Brooks Boundary. This, as we've come to find out, this, the law does a pretty good job of protecting kids from these type of folks, potential victims, if you say, in daycares and schools and things like that. But there's certainly, we have found out, obviously, there's a big gap there now when it comes to the victim, and it's sitting right in front of us right now. And it's, again, how else can you explain that when somebody that did what he did to my 14-year-old daughter is allowed to just come right back in and just go wherever he wants to go outside of in my house. So that's obviously why we're here today, to express our concern and try to see if we could get this gap closed. And I'm sure this is obviously for Brooke as it hits home for us, but there's got to be other folks going through this as well that hopefully can help them as well. So I'm sure you're going to hear and have heard from sexual offenders and their supporters about how they think these victims should be dealing with this, and this crime and the trauma that follows this crime. But I think it's pretty important that you kind of hear from the victims and their families what they're going through, and it's bad enough, and I know there's some data out there that supports certain percentages of reoffense rate for this, and so that fear, is obviously a bit paralyzing for the victim. But it's what's even more that we found out is just the trauma. It's the trauma of the seeing him every day, seeing him with other girls out in front, and things that are going on, and it's just, you see the immediate triggers, you see the immediate impact, you see the immediate behavior that comes with that, and we have done many treatments, many hospital stays, mental addictions, things that she chooses to cover these things up, and it seems we get to a good place, and then it's amazing how fast it can retract. And it's, as my wife said, it's really unfortunate that somebody, adult, child especially, has to live in fear and be kind of a hostage of their own home. And I mean, I literally, when she's there, I have to step outside and peek around the corner to make sure he's not outside. If we just go check the mail, if we want to walk out to the garden, we want to see how the things are doing. It's I can walk out and I have to look, and that's not right. So again, he robbed her a long time ago, 10 years ago, of her self-worth, her self-esteem, and her purity. And that happened at a very young age. And he's been holding that hostage for 10 years now. And it's important that she gets those back and can be able to stand on her own 2 feet and confront this. And I think this bill will at least take a huge step in helping her not to have to, it will help her continue her recovery and not have to deal with the setbacks that she's dealing with today. So thank you again for hearing us, and on behalf of my daughter, Brooke, for your time.
Thank you both for being here. Senator Saffarini.
Yes, first, thank you both very much for your courage. Thank you. And for coming before us and sharing your story. And second, to the sponsor of this bill, I see on page 4 of the bill that it takes effect September 1st. I wonder if we could amend the bill on the floor for immediate effect with a 2/3 vote.
Yes, ma'am. That's a great amendment.
Good. Thank you. Thank you.
Members, any other questions for the Stevensons? Thank y'all. Thank you for being here.
Appreciate you.
We'll open public testimony on House Bill 4061, and the chair calls David Gonzalez, Mary Sue Molnar, J. Dan Gum, and Richard Gladden. So we're looking for David Gonzalez, Mary Sue Molnar, J. Dan Gum, Richard Gladden. Also, the chair calls Barrett Tesson. Barrett Tesson. In case, all right. We'll start on my left, your right. So introduce yourself and give your testimony. Go ahead.
My name is J.D.N. Gum, and I'm testifying on behalf of our organization, Forgiven Felons, as well as myself. And I'm opposed to some of the language in this bill. I am the founder of Forgiven Felons, where we help people with a past realize their future. We help formerly incarcerated individuals, including registered persons, get back on their feet after incarceration and become productive citizens. I myself, as of April 18th, have been out 17 years. We also have 2 transitional houses in the Dallas area. I'm not a registered person, nor do I have any in my family of origin, but I have many registered persons in my family of choice and the registered persons' families. I want to talk about language, the language in the bill. Language is important. Language can change a culture, a moment. It can start a revolution. It can also undo years of rehabilitative work. In our transitional house, if one resident makes a dumb decision, I speak to them in a language where I don't jeopardize the rest of the residents' rehabilitation. I understand the case and the intentions in which my personal friend, Mr. Schatzline, authored the bill, and I can't imagine what the family's going through, and it shouldn't have to happen. But I can also assure you, having worked side by side with parole and registered people for the last 17 years, this is not the norm. This is an anomaly. I believe the changes that have been made are great, the changes that have been made, but some remaining language is still detrimental to some that have worked hard to reconcile with their families and become rehabilitated. Like I said, I work side by side with parole, TDCJ, including registered parolees, and I can tell you that when they get out of prison, they do not nor are ever made aware of their victims living. I think the 25 feet is not in line with parole, which is 500 feet. Other states, Arizona and Tennessee, which are 1,000 feet. While appreciating the addition of the words intentional and knowing, I'm almost done.
And you're out.
Oh, I also know that a registered person will most likely be assumed to be in that area intentionally and not given the benefit of the doubt. Lastly, this bill will prohibit my dear friend, Stephanie, whom I spoke with last week, from having her parents into her home for family gatherings or take them into their home to care for them as they are aging, because her dad was the offender. The family reconciled years ago and all spend time together on a regular basis. Grandkids, the dad. But this bill, as written, would still not allow them to continue to do that. As this is a huge concern, as there are lots of families who I work with on parole who have reconciled.
We do have other witnesses, so kind of finish this thought.
All right, last sentence, last. This bill would be better if you just added a victim opt-out option. for these cases, which are not an anomaly. People on parole whose victim is a family member are already not allowed to reconcile with their victim.
Thanks for your testimony.
All right.
Introduce yourself. Give us your testimony.
Thank you, Mr. Chairman. My name is Richard Gladden. I'm speaking on behalf of myself only, and I'm speaking in opposition to this legislation. I'm a criminal defense lawyer, so I do encounter these issues a whole lot as far as compliance with Chapter 62 of the Code of Criminal Procedure. I have read and have a copy of the committee substitute. I certainly appreciate the fact that we will be making felons out of people who engage in conduct knowingly that's prohibited, because that was not the case with the original House bill. The original House bill's bill analysis said it did not create a criminal offense. It also did not include in the caption to the bill that it would create a criminal offense. Both of those things violated House rules, and I assume they would if the same were true with your committee substitute, which I do note doesn't say anything about creating a felony offense in the caption. The problems I see, though, that still exist is the consent element, is you have people who are married to their minor victims once they become adults. You don't have, like every other state I've seen, a consent thing where if the family is reconciled and there's a victim within the family, so they can get together on Christmas at maybe the victim's house, a written consent that would exempt the registrant from having to comply with this provision. The next thing that's not even been considered at all, given the haphazard way in which this legislation was presented in the House and not considered with any meaningful sense, is that what if the victim lives within 2,500 feet of a hospital and you've only got one emergency hospital in town? What is a registrant supposed to do then when they're being rushed by an ambulance to the hospital? The same kind of things apply to churches and places of worship and other situations where you have child safety zones. You've got exemptions for people going to community service, going to church, things of that nature. That's been totally ignored because this bill wasn't thought out before it was proposed in the House, and I urge you to vote against it unless or until we have a bill that makes sense. Thank you.
Thanks for your testimony. Senator, do you want to ask now or when we get through the witnesses?
Just because he's a criminal defense, one of the questions.
Go ahead, Senator.
Thank you, Mr. Chairman. Sir, you said you're a criminal defense attorney, so you talked about the family. I was trying to think about these family dynamics, and I could envision the example where you mentioned the grandfather who has reconciled with the victim and they get together for Christmas. You testified to that. So let's use this example. Now, if you don't have the exemption in the bill could be weaponized by someone in the family who's decided that they're still not okay with the criminal, the former criminal,
yes,
that has reconciled. So they could use the bill against them, could they not?
No, they'd have to be the victim of the offense. You would have a written consent by the victim of the person's offense.
I think you're missing my point. What I'm saying is if we don't write in there an opt-out that the victim agrees, that the victim says, I'm okay with this, then someone else in the family who might still not be okay with what happened could use it against them.
Well, sure. And of course, and I want to point one other thing out. Generally, these kinds of regulations are to eliminate or diminish risk of sexual violence towards minors.
Right.
We're on a different category in this situation, as this bill is designed to diminish emotional harm or trauma to victims who don't want to encounter or visualize, and I assume maybe not even on TV or hear them on the radio. So we're not talking about eliminating the risk of sexual harm or a threat to the public. We're talking about trying to remedy the harm, emotional harm, to victims who may encounter and it's not really a next door neighbor thing. You've got a 2,500-foot separate zone, and if you're really wanting to eliminate harm, emotional harm, you can make it 500 miles from where the victim lives. And they'd still see him on TV maybe from time to time. But that's my point. This is not really consistent with what we've done before.
Yeah, but I guess I'm trying to think through the potential for the victim opt-out situation where in a family, the victim could have reconciled with the person, and yet someone else in the family would not feel it was appropriate, and that if we don't create a victim opt-out, then that person could use this bill against them.
I think if the victim signed a consent, I don't think someone else would be able to enforce this because the defendant, the former, or the registrant in this case, it would be strictly the consent of the victim. And that is the way I read it.
Yeah.
And of course, anybody in the neighborhood that doesn't like the registrant can complain too, but that wouldn't really make any difference.
Thank you.
Thanks, Senator Menendez. Welcome, introduce yourself, give us your testimony.
Hi, Senator Hughes. I'm sorry, I have laryngitis, but I'll do the best I can.
No problem.
I'm opposed to the bill also because of the victim opt-out. There are many, many victims who have, through counseling and restorative justice type of measures, they've reconnected and reconciled with the person who offended against them. It's their choice to do that. If a victim finds that their healing will be found in reconciling and reconnecting, that's their choice. And this bill takes that away from them. I have a certain instance where a lady's been blowing up my phone. She's wanting to know if this bill passes, can my brother still come for Christmas and birthday parties and family gatherings? And I'm saying not if it passes without an opt-out. So I think it's a good bill for people like Miss Brooke. I don't think the guy should have moved in at all. I think he should be gone. That's a given. But there's a lot of victims out there who are trying to reconnect and heal in a different way. And there needs to be an opt-out for those victims. Also, my only other problem is the 2,500 foot. I think that's a little broad. I'm looking at Arizona and Tennessee, and they both have 1,000 foot ordinance. I think 1,000 foot is plenty to keep somebody, because it would narrow the problem of, let's say that somebody already lives in that area. They don't know their victim lives there. The victim doesn't know they live there, and nobody really cares. 1,000 foot is a lot. It's a lot of distance. 1,000 foot would do the job, I believe, and. That's all I got. I'm about out of time anyway. Thank you very much. Appreciate it.
Thank you for your testimony. Welcome, introduce yourself, and go ahead.
My name is David Gonzalez, representing the Texas Criminal Defense Lawyers Association, testifying in opposition. Just 3 matters. First, thank you for the substitute. It does address some of the constitutional concerns that we had related to the word intentionally. In terms of the big print versus the fine print, our organization has no issue with the intent. And actually, after in 2021, you passed provisions that mandate prosecutors get protective orders. So upon every conviction, a prosecutor must file for a mandatory protective order. So that situation does not happen. And someone within 200 feet can't live there without then triggering a new criminal offense. The text of the bill that says we're going to tell people this notice when they leave prison is fantastic, so there's no inadvertent problems, and it's very, very clear. Our issue is not that notice, it's just that when it applies retroactively to everybody on the registry now, it just becomes logistically difficult first. So if Section 4 of the bill is changed to make it effective immediately, we have no issue. It's just Section 4 says this applies regardless of when the offense occurred, and that is what I think everyone is worried about, kind of the administrative nightmare of who's notifying when this happens. But if it's prospective, I think there's no constitutional issue of an ex post facto clause now where we've got a crime that is now being committed by somebody that didn't know at the time it was an offense. It's different if there's a protective order. It's different if there's a notice or a hearing. That's our concern.
Thanks for your testimony. Welcome, introduce yourself, and go ahead with your testimony.
Thank you, Mr. Chairman. My name is Barrett Tesson. I'm here this morning testifying on behalf of myself, and I am against this bill. My main concern was rectified with the committee substitute, so I do appreciate that. I want to echo Ms. Mary Sue's concerns about other states. For example, Arizona, Tennessee have just a 1,000-foot radius, not 2,500. And I would like to bring maybe a different perspective. I am not on the victim side. I will concede. I have no problem stating that I would say anyone would think it is inappropriate and definitely should be unlawful for someone to move right back next door. But I'm on the offender side. I am listed on the Texas registry. I committed my offense when I was 18 years old. I'm now 33. I've been married 11 years, and I have 3 children, aged 4, 7, and 9. And every day we worry about, did I tell the registration about the car? Did we move? Did we get a new job? And I think people change, and I think, as much empathy that is appropriate for the victim side, I think that a lot of people rehabilitate and reform, and they made a mistake in adolescence, and they've married and have children, are working hard, and we live in fear the rest of our lives for, was there a technical violation that I didn't update? And this would be one more thing that I'd have to worry about. Again, a large part of it was rectified with the substitute, knowingly going in. But I think the felony charge is a steep penalty, and I think other states, again, Arizona and Tennessee have a misdemeanor penalty for this offense, and I appreciate your time.
Thank you for your testimony. Senator Perry.
I just say, generally speaking, I'm sorry you have a little bit of fear that you may technically violate something. That's a small penance to pay for what those victims were robbed of. I like your 500-mile deal. Now, I also understand people are redeemable, and if victims can reconcile that, that's only by God's grace, because nobody else humanly could reconcile with that. So victim opt-outs are conversations worth having. But it really is unconscionable for you to point out your troubles about maybe missing a technicality that could put you back into harm's way legally, when you have literally robbed a child of future into perpetuity, and the burden is laid on it. So don't lay that stuff on me in this committee. That's just not right. God has the power to change people, and I hope people do. But there's a consequence to our actions, and we will live with those. But 2,500 feet is too short in my book, because it's 60 yards, basically. You know what? I can see a mile and knock a deer down with a rifle. So if I can see it, I shouldn't have to be a part of it. This guy is evil, and he's taunting them, and the psychological warfare he has perpetrated on that victim should never, ever be. And I know y'all say that's not excusable, and you've got other examples where it doesn't apply, but that's what this bill's about, is stopping that. So I hear you. I'm a guy of second chances. Gosh knows I've had a few. But man, the consequences of having those second chances granted, that's on y'all. People that are in that situation, and I won't ever support easing your conscience or your fear that you may fall out of the system because you didn't do something right. Because the people that were victimized at this age, they're out of the system. They don't get to have the benefits of maturing at the right age with the right growth and the right experiences of life, because that was stolen from them. So it's just unconscionable that we would say, well, I'm worried I might miss the beat here. That's not right.
Thank you, Senator Perry. Senator Paxton.
Thank you, Mr. Chairman, and thank you for bringing this bill. I think it addresses a very real issue, and I appreciate you bringing it forward. Mr. Gom, I had a question for you, and I appreciate your ministry, and I've encountered your ministry testifying on a number of bills throughout the session, and appreciate what you do. And as I've been listening to the testimony, one of the things I was thinking about is, at least for me, part of someone who truly is rehabilitated in a situation where they have, committed a sexual offense against a child or anyone else, it would seem to me personally that part of true rehabilitation would be a tremendous sense of remorse and compassion for the victim, which to me would translate into, you know what, if that person needs me to be 2 miles away, 5 miles away, the last thing I want to do is to create more harm, regardless if I've changed. Do you disagree with that?
I don't at all. I 100% wholeheartedly agree with you. And I would say, as working alongside parolees who are registered people and have many friends who are registered persons, I would say the most part of those line up exactly with what you say. Like I said, this person that moved in next door, he is not the norm of the way almost all other registered people think in their mindset. I can promise you that because I've walked with them. Our family are friends with other families that have, offenders, registered people in their families. And the biggest part for me, the biggest concern of this bill is to see over the last 17 years, the families that did have the offender inside the family that have reconciled. And the forgiveness is there, although it's not understood completely how that can happen. The family reconciles, and to see there not be some sort of just, I don't know how we would do it, but to write the bill based on this one idiot that needs to be away for a long time. And by the way, cities do have complete jurisdiction to make those laws just like that, to make it illegal. The cities do it all over the state of Texas. But I promise you, that's not the norm. And that guy needs to pay, that guy should be in prison, in my opinion. But to see this bill in its form right now would undo and break up so many families who are encouraged by their loved one, rehabilitation and all the family gatherings that they have. Stephanie, her family, she was a victim of her stepdad when she was a minor. And they had it all reconciled, everything was done, and then somebody ended up hearing about it in the church or whatever, and even they talked to the pastor and said, we know all what happened and it's been forgiven, but they took it to court anyway, and they told on him. He went and did his time. He got out while he was on 10-year probation or parole, because he served prison time and a probation. He could not see his daughters, and his daughters came to see him while he was in prison and didn't even know that they could, but they had already reconciled. And now he's off paper, and they get together every holiday, and that just and this is not an anomaly. I have probably 100 of these type of stories where families have reconciled. And while I agree with Mr. Perry, the inconvenience of making sure that you're not violating anything, I do agree with Mr. Perry on that. But at the same time, we can't undo all this healthy, positive rehabilitation, because that's our goal, right? We want these people to rehabilitate and not reoffend and reconnect with their family in a healthy way. And this bill would undo all of that just because of one idiot.
Well, I think I don't see it the same way. I don't think this bill undoes all of that. I think that, personally, I think that this should be the rule. And if there are exceptions where there have been, I think the default should be protecting the victim. And I'm certainly open to considering these situations that you share, but I think that the default protection has to be with the victim. And I have to disagree with you. I'm glad that you're married now, and I'm glad for your family that you're out of this past. But I think the person who truly has reformed is going to have a higher regard for the experience of the victim than for themselves. That's my opinion. And I think that the law should be that way. And I think I appreciate you bringing up the possible opt-out for certain kinds of situations. I think there would have to be very strict protections around coercion of opting out. That could, in families, we just know that's part of it. So that's something that I would think would definitely need to be considered. But thank you all for your testimony today.
Members, any other questions? Thank each witness for being here. Anyone else wishing to testify on, for, or against House Bill 4061? Seeing and hearing none, public testimony is closed. The bill's left pending at this time. Senate Committee on State Affairs stands in recess until adjournment or final recess of the Senate today. So this hearing will continue upon adjournment or final recess of the Senate today. Thank you very much. Good afternoon.